Here in the matter of the people of the state of Michigan versus Shamika McCallie, case numbers 20-02124-FH and 25-02388-FH. And this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court today on Mr. Beeson's request to withdraw his counsel in this matter. That is also supported by a certified or a notarized letter I received from Miss McCallie requesting new counsel due to a breakdown in the relationship. I would invite counsel, will you please place your appearances on the record at this time?
Tiffany Burks on behalf of the people.
And Mr. Beeson, you're muted.
Sorry. John Beeson, Your Honor.
Thank you, Mr. Beeson. Anything to add to the motion, Mr. Beeson?
No, Your Honor. Ms. McCauley is present, but she has her audio on.
Yes, no, that's fine. Any position from the people on the motion to withdraw his counsel?
No, Your Honor.
All right. Well, in that case, I will grant the motion to withdraw because Ms. McCallie has indicated a breakdown in the relationship. And Ms. McCallie, is it your intention at this point to request appointed counsel, or are you going to hire new counsel on your own?
This is a motion for me to get off probation, right?
I think there also is a motion to terminate probation in here. You know what? Let me handle the counsel one first so we can determine whether you're supposed to speak on your own behalf for probation. I had two motions, Mr. Beeson's motion to withdraw, and then also, yes, you're correct. Your next one up is yours to get from probation. So, what's your intention going forward with regard to an attorney?
I do not wish to have Mr. Beeson represent me, Your Honor. I made it clear to Mr. Beeson that I did not wish to sign a waiver, and he manipulated me into signing the waiver, did not give me a copy, and I had to obtain a copy of that waiver, which is why my case was bonded over. It has also been on my record that I have absconded for 2 years, and I've never ran. This is a major problem. It has stopped me from being able to better myself, Your Honor. I am very frustrated. I don't owe you guys anything. I don't owe you guys any community service, any money, and I am still being punished.
Buckle up. Guys, today we're going to dive into a courtroom showdown where chaos meets consequence. Right from the start, we're introduced to a case that's about to spiral from calm procedure to pure tension. The tone is set, the stakes are clear, and you can already feel the storm brewing behind polite introductions. This is not your typical hearing. It's about to get personal, loud, and unforgettable.
All right.
Your Honor, may I address that real quickly? Just so
you may, Mr. Beeson.
The record is, I have nothing to do with her previous, whether or not she has a notice on her file about fleeing. That was my concern. Secondly, Judge found over Ms. Cawley from the prelim. She signed a circuit court waiver. Her case is already bound over. And I explained to her that by signing the document, she did not have to attend in person for the plea not guilty from the circuit court judge. So I don't know if she understood that or not, but you can clearly see there's a breakdown. So I ask the court to grant my motion.
Yep, no, I can see the breakdown in the relationship. I will grant the motion and allow your withdrawal at this time, Mr. Beeson. And I'll ask you, Ms. McCallie, is it your intention to hire a new attorney, or would you like me to appoint an attorney or have the defender's office assign an attorney to represent you at this time at no charge?
No, I would like to get this motion going. I don't need an attorney. I'm not.
I'll continue with your motion today. I'm just thinking going forward. And is this the only thing you're in front of me on, or is there? Because my review of the case indicates there might be another case coming here.
Driving while intoxicated was bonded over in front of you. Also.
Okay. Who's representing you on that one, Miss McCallie?
I am currently looking for someone to represent me. I have have a lot of support. I am in the FIT program, and we are looking for an attorney to represent me in this situation, also to take care of that absconding that was on my record. That has really put me in a bad situation.
Okay. All right. Well, what I have here is I extended, let's see, probation here for 90 days because of that OWI that was pending in 61st and has now been bound over and will be in front of me in May. And I amended the discharge date from probation to August 23rd of this year based on that. And, based on the additional charge for OWI, I don't see any alternative here but to keep you on probation for that time. Are you still wearing the scram, Miss McKaylee?
I am, Your Honor, and I have been wearing it since November. I have no problem with wearing the scrim. I am in cosmetology school because I tried to take CNA and I was denied because I was listed as absconded too for 2 years, which
Yeah,
makes
no,
my guidelines
yeah.
go up, which is a major problem and it's not being acknowledged. So I need an attorney behind all of this stuff that's going on. The amended sentence was not represented to me. When it was represented to me, it was represented to me first without a signature by you. It's just been, I haven't got anything in the mail. Um, it's
Do
been a
we, do
lot.
we have a good mailing address for you, Miss McKaylee?
Yes, you guys have a good mailing address for me.
What is your current address that we should send stuff to? Okay, yep, that is what we show in the court record here. So that is good. We're at least sending stuff to the right location. What I will do, well, in the meantime, prior to that conference, and Mr. Beeson has represented you on that case up until this point. Now you don't have an attorney. What I will do is direct you to obtain an attorney within the next 2 weeks. Yeah, so that's, gosh, 2 weeks is just going to put you a week before that. If you don't have an attorney prior to that date, what I will do is I will appoint, a court-appointed attorney to represent you, so you have representation at that hearing. So today's order, though I'm going to keep you on probation, it will direct you to obtain counsel on the new case of your choice, or I'll appoint counsel.
Your Honor, this case has been pushed out and it is hindering me. You guys extended my probation past my max date.
All right, guys, this is where things start to heat up. The judge officially opens the floor, calling out case numbers like a roll call before battle. The motion to withdraw counsel might sound procedural, but in moments, it's the fuse that ignites everything. Behind the formalities, you can sense the discomfort building, each word laced with tension as the courtroom readies for confrontation.
No, I did, but given the
for 60 days, you did it for 6 months.
Yep, well, and given the circumstances, when I have because I do have you on probation for OWI, and if that ever happens and I get someone else that picks up another OWI charge, I keep them. I'm not treating you differently than I treat anyone else. I do keep folks on probation, and it's mainly because I want to be able to monitor whether you're drinking and driving during the probationary period. If you were, then I would take the additional step of holding you in jail. You're not indicating any of those problems, and the scram, as far as I know, has been good for you. So I mean that you've been compliant with the scram conditions, which is a good thing. That gives me the assurance that the public's safe while you're out there while we get the new case worked out. So that's all information I can give you.
Judge Rossi, you also told me that you were going to release me from probation back in September, and that did not happen. Like, I am getting the runaround with you guys, and I do not feel like this has been fair. I am not disrespectful, so I'm not going to question your authority during court. If you tell me something that you're going to do, that's what I expect. That was supposed to be done before this event even occurred. The reckless driving was thrown out, so I don't even know why you guys would be coming at me for a DUI.
Okay, yeah, well, the indicator I have here is that it's a reckless and an OWI in the 61st District Court. Is that what you, or did you just get bound over on the reckless?
I didn't get bonded. The reckless was dismissed
I
with
see. Oh, but I still
prejudice.
have the OWI coming in front.
Right.
Yeah, no, and that's the more serious thing, and that's what's going to require, to be addressed by your lawyer.
Your Honor, you got, I wasn't driving, so this is just hindering my life.
No, I get it. And I understand that pending charges and the absconding charge and all of those things have a serious impact on your life. And my flip side of it is, I do apologize. I know it can feel like the system kind of pushes and, moves you around without much regard to what's really happening out there. However, I can tell you, from my perspective, particularly with OWI cases, I am in favor of resolving them. However, I've got to look at the, unique situation of the concern about public safety when I've got someone with OWI charges because, as you know, if you got behind the wheel drinking or having used something, as I describe it, it's like shooting a gun into a crowd. It could, you might not hurt anyone, but then again, you might kill someone. And it's just too much of a chance for me as a judge to take. So I've got to be extra cautious with OWI charges, and I always am. Just for the public safety aspect. So that's the best explanation I can give you at the moment. However, once we get an attorney and we get that status conference, we can address those things in front of me. I can advise you if you plead guilty on another OWI charge, the likelihood is that you'll remain on probation for an additional 3 years. That's my policy, at least on every OWI third charge that comes in front of me. So just so you're, got some parameters to think about going forward. And like I say, if you're successful hiring a new attorney, have that attorney file an appearance. If I don't see an appearance by a week before that status conference, I'll send it over to the county and have an attorney appointed.
If I don't, if I'm not able to get counsel, I don't wish for nobody from the courts to represent me, Your Honor. I have no faith in you guys.
Here's where the cracks start to show. The defendant bursts with frustration, claiming manipulation, betrayal, and injustice. Her voice shakes but cuts like steel, accusing her attorney of deceiving her. It's no longer a quiet legal discussion, it's personal. The air thickens with defiance and disbelief, and you can almost hear the judge trying to keep control as emotions spill across the virtual courtroom.
No, well, and all I can tell you is those offices are independent, the defender's office and our court-appointed counsel list, other than the fact that I'm paid by the state of Michigan, but my staff and the rest of the court's paid for by the county, and, the defender system is also paid by the state of Michigan and the county. However, we don't have any control. They should be an independent advocate for you. In other words, they don't work for me. They're there to represent you in the system. So, and I can tell you, you'll be much better off going forward with an attorney than going forward on your own, because the attorneys do.
You guys don't have me driving. This case is pointless. It's just holding up my life. That's all it's doing.
Yeah, no, and that is very much the effect of this type of
And you
charge.
guys extended my probation past my max date, and
They
I don't
do.
owe you guys anything. I've done all my community service.
No, the number one concern here is the new charge. At this point, Ms. McKillian, we'll deal with that when I see you in May.
So the reckless driving, if they dismiss that, I don't understand why they're still pushing for the DUI.
Yep, that's a question for the prosecutor and for your attorney to discuss, either prior to that conference or at that conference. So, like I say, if you're successful hiring an attorney, have them file an appearance and they can get talking to the prosecutor's office. If not, I'll get someone appointed. The faster that happens, obviously, whether you hire an attorney or I appoint an attorney, the more communication they can have in advance of that conference to address your concerns.
So, okay, can you tell me about why you told me you're going to let me off probation and did not do it?
Well, I can't tell you exactly because I unfortunately don't remember every single thing I say when I'm
But it should
in
be
court.
on record, Your Honor. It should be on record. We did
Yeah,
that
no, and
before.
I
I
do have
lost
the
my
one.
job behind being on scram again, like I told you it was gonna.
Just when the tension peaks, everything halts for an unexpected sponsor break. The chaos gives way to calm as the host pivots into smooth ad mode, selling earbuds with the same energy used to narrate courtroom drama. It's oddly fitting, a quick breath before diving back into the storm. The sudden switch reminds you that even in the middle of conflict, production must roll on.
I lost my job and I was like, okay, that's fine. I got some health issues going on and I'm gonna be off probation so I can just sit down and go to school. I could not do that because of the absconding.
Yeah. Well, and I know
Then
why I
when
put
it,
you on the scram was because,
the
the
violation,
violation, right? That I can tell you. But I can't say, yeah, and I can't
but you
say
didn't
that
take me off
obviously.
probation like you told me you would. You said if you do scram with no hiccups, I'm going to take you off. That did not happen.
And I had you on scram starting on March 8th, and you've been on now for, what are we at here?
March
We're not,
8th. No, 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 no. Your Honor, you put me
oh,
on
that's March
scram.
8th. Oh, I see. Yeah, when did we put the scram on? You said
I've been on
November.
scram this time since November. Before I got off scram in September and I was supposed to be let off of probation. That was what you told me in court. I told you I work at a medical factory and that I believe I will be let go because of this scram because it's a very conservative place. I was let go. When
Yep.
it came
No.
time for me to get off of scram off scram, I was told by Shannon that I'm not eligible to be let off of probation, which I don't understand why you would even tell me that.
Yep.
That
No,
feels as though it was to mislead me so I would accept the scram. I did, which I've been on scram 4 or 5 times. I've never dropped dirty on scram.
Back to the drama. The defense clarifies, the judge listens, and the withdrawal motion is granted. But beneath the formal approval, you can feel the weight of disconnection. The defendant now stands alone. When asked if she'll get a new attorney or go it solo, her hesitation speaks volumes. This is the turning point. From guided defense to uncertain self-representation, and the tone turns quietly foreboding.
yeah, no,
Never. I am
that's,
not being acknowledged for none of this time or none of this work that I'm putting in. My life is only being held up.
yeah, and I see what you're saying here because
I
you
put
started
myself
that
in treatment.
probation, looks like on February 23rd, 22. Well, and the other explanation as to why I would have
22.
not let you off. Yeah, well, that's when this case started, right? When I put you on probation in the first place. Would have been February
This case is
22.
from 2020. Actually, 2019 is when the case was
Yeah,
when
though
I
we
closed.
probably entered the order, the plea resolving the case could have been 2022. Uh,
Okay, so what do I do about, I don't want to be disrespectful, but like, what do I do about you telling me one thing and that not happening?
well, the only safe way, as I tell people in anything, is to have me reduce it to an order. There are two ways that can happen. I can do it on the record in court, and your attorney can obtain transcripts of what I say in court, and I do honor that. If I say it on the record in court, then I do follow what I said. And then second is, I do a written order. Sometimes your attorney will generate a written order for me to sign, and then we have it in the record. So then when I make a representation like that, and that again assumes nothing changed. And I look here and I say, well, what changed? And of course, the biggest change was you picked up that additional OWI.
That was 2 months after I was supposed to be already off.
Yeah, and I'm
And
looking at
it's not, I
this.
wasn't even driving. So it's just me being at a scene. You got my name coming up, and now because
Yep.
I have a history of DUI is really why I feel like you guys are coming after me. But that's personal feelings. And
Yep.
I'm
Well,
not
and I
gonna
don't make the charge decision. That's entirely the prosecutor's office, and then it gets in front of me, and they'll give you an evaluation based on the facts of the case. It doesn't just because you're charged with it does not mean, of course, that you'll ultimately be convicted of it. But while it is a pending charge, and because of the prior I need to be cautious and extend the
but
probationary.
why didn't you follow your order of taking me off probation?
Well, I think the number one reason that I can give you on that was picking up that
I didn't have a case when it
I
came
see.
time for
Right,
me
well,
to get off
and
probation.
your probation would have ended with the scram is what you're saying. Well, and it's
In September.
right about the same time because I put you on scram
No.
November. You'd have been on there for at least a couple of months till January.
Well, I'm talking about September of 2024. I was supposed to be off of probation, off of scram, done. That was the agreement you told me in court. You said, I feel like it's necessary for you to do scram. I told you then, I have done scram. I think then it was like 3 times. And I've never had no issue with scram. You said, well, you do scram this time and you have no hiccups. I am going to let you off probation. That did not happen. That was the first week of September when I questioned William Shannick about it because I was transferred back to him from Dominic Milton. He said, I remember the judge saying that in court, and he told me he was going to look into it. And then he said, oh, you're not eligible to be let off of probation early. So that's where my frustration come in at.
Yeah,
And
I
then
would
this case
understand it.
being
And,
totally BS, and it's like really holding on my life and stopping me from being able to better myself.
And here's the climax. The defendant openly rejects the court, declaring she has no faith in the system. The judge stays firm, warning her about OWI consequences, even drawing stark analogies about danger and responsibility. It's a moment of raw defiance and cold reality colliding. By the end, the tension hits its peak. Both sides unmoved, both sure they're right. Don't forget to like this video, subscribe to the channel, and we'll see you in the next one.
I get it. And, all those are valid considerations. However, the only thing I can posit there is that what got in the middle of this is we were coming close to the time when you would have been eligible because of the expiration of the 3 years of I put everyone that's an OWI third on 3 years of probation. Sometimes I let people off 90 days early, from probation, when they have a good record. And that's what would have happened, had you,
It didn't happen, is what I'm telling you. It didn't happen. This case is 2 months after I was supposed to be off of probation. You did not let me off.
yeah, no, and the only thing I can tell you is what happened there is you picked up that.
Your Honor, I picked it up 2 months after you told me you were supposed to let me off probation.
Well, that was contingent on nothing else happening, and when you
I
pick
was
up a new
supposed to be
charge,
off, Your Honor. You keep saying it's because of this new case.
yeah,
I was supposed to be
no,
off September. This case was caught at the end of October.
yeah,
And
I
like I
get
said,
it.
I wasn't driving. I went and hired an attorney. He did not do what I told him to do.
Well, and I don't have
I'm
any
really
facts
feeling like
about
I
that
need to
new
get
case.
other people involved because this is ridiculous. You guys have
Well,
had me as absconded for 2 years. 2 years. I've been to jail. I've been in front of you. How is it possible?
yep, and I'd
I
have
am pissed.
to.
I'm not even gonna lie because I am trying to be better. I am trying to better myself to be a good example for my children, to make my life more financially stable, and you guys are hindering me.
Well, and that I can certainly see how you'd have the feeling. However, I got to deal with the new charge that's in front of me, and that's what's gonna, kind of set the
Well,
course
I
for the
have to
next
go in
3
front of you.
years.
I don't see why you're keeping me, why you're denying my motion to be off probation. I
Yep,
have to go in
no,
front of you. You guys dismissed the reckless driving, so I don't know how you're going to give me with a driving period because I wasn't driving. I was
well,
with
you're
a
gonna have
licensed
to.
driver, wasn't in the car or nothing.
I can't weigh in on that because I don't know any of the facts of the new case, but you're going to have to address that with your new attorney.
Okay,
Good luck to you, Miss McKaylee.
sure.